Welcome back, legal minds and practitioners, to today's Explainer. All right, today we are tackling a beast. You know the one. It's the statute that haunts pretty much every young lawyer and law student, the Code of Civil Procedure, 1908. Look, in Pakistan alone, the civil courts are handling hundreds of thousands of suits every single year. Yet the very rule book designed to make all of that orderly is so often seen as opaque, fragmented, and honestly, just forbidding. We see judgments get delayed, and we see tiny procedural missteps completely derail otherwise meritorious claims. So, today, we're fixing that. We are going to decode the CPC and build the intellectual foundation you need to actually navigate civil litigation with confidence.
But before we get totally lost in the weeds of sections and orders, I want to pose a really provocative question to you. What good is a legal right if you have absolutely no way to enforce it? Seriously, think about it. You could have a flawlessly drafted contract or crystal clear title to a piece of prime real estate, but those paper rights, they are completely meaningless without a reliable, structured mechanism to vindicate them when somebody actually breaches that contract or trespasses on your land.
Okay, let's dive into this architectural blueprint. We've got 5 key areas to cover today. First, the engine of justice. Second, substantive versus procedural law. Third, the pillars of civil justice. Fourth, the anatomy of the code. And finally, the practitioner's reality.
Starting right off with Part 1, the engine of justice.
If you really want to master civil litigation, you have to shift your perspective, like today. You need to stop viewing the CPC as this dry, technical hurdle standing in your way, and start seeing it as the vital machinery that actually powers the courts. Civil procedure is the body of rules governing exactly how civil rights are enforced. It's the framework that literally transforms a private, messy grievance into a judicially enforceable claim. And listen, this isn't just about statutory mechanics. This is the practical, on-the-ground implementation of a fair trial. Specifically, we're talking about Article 10A of the Constitution of Pakistan. Without these step-by-step rules, your constitutional right to due process is just abstract theory.
I absolutely love this quote because it really zooms out to the big picture. A functional civil justice system promotes social stability, economic growth, protection of rights, and public confidence in the rule of law. Basically, without this structured framework, there's no peaceful settlement of disputes. There's no preventing unlawful conduct. People would literally just take the law into their own hands. So, the procedure you're studying, it's actually the bedrock of civic order.
Moving on to Section 2, substantive versus procedural law.
And this is a foundational distinction that every single law student, judicial officer, and junior advocate must internalize from day one. Let's draw a really direct contrast here. Substantive law defines your rights and liabilities. Procedural law enforces them. Think of it through a simple analogy. Substantive law, like the Contract Act or the Transfer of Property Act, is the what? It's the engine block. But procedural law, like the CPC, is the how. It's the transmission. It's the machinery that actually puts the power to the wheels. If you know the Contract Act inside and out, but you have no idea how to draft a plaint or serve a summons under the CPC, you literally cannot help your client. You've got the what, but you completely lack the how.
Which brings us to Section 3, the pillars of civil justice. So what are the actual goals of all this procedural machinery? Look, the framers of the 1908 Code weren't just making up rules to torture us. They were pursuing 4 interlocking objectives to prevent arbitrary rulings. Let's quickly unpack these pillars. First up, uniformity. Before the CPC, procedure varied wildly from court to court. A single code cuts out that arbitrariness. Second is fairness. The code builds natural justice, meaning notice and the right to actually be heard, into every single major step. Third is efficiency. By prescribing fixed stages like the plaint, the written statement, framing of issues, and evidence, it channels the chaos of litigation into an orderly sequence. And fourth, finality. Litigation has to end at some point, right? The CPC includes doctrines like res judicata, meaning a matter that's already been judged cannot be endlessly pursued by the same parties. These exist specifically to give absolute stability to civil rights. You just can't be dragged to court twice over the exact same cause. Okay, Section 4, anatomy of the code.
Let's transition to the structural blueprint itself. This dual structure is exactly what frustrates people when they first crack open the CPC. I mean, the sheer scale is massive. We are talking about 158 sections and 51 orders, with the orders tucked away in Schedule I. For a young advocate, that looks incredibly daunting. But let me reassure you, it is actually highly systematic once you get the hang of how it's divided.
Now, what's really interesting about this breakdown is how the labor is divided. The sections contain the substantive procedural principles. They lay the foundation. For instance, Section 9 grants civil courts their general jurisdiction to try all civil suits. It's the core authority. But, and here's the kicker, the sections don't tell you how to file that suit. That is exactly where the orders and rules come in. They give you the detailed step-by-step mechanics. Order 7, for example, is your mandatory checklist for drafting a plaint. Both the sections and the orders are equally binding, but they do totally different jobs. Sections give the authority, orders provide the playbook.
Finally, let's look at Section 5, the practitioner's reality.
Let's step out of the classroom for a second and bring these abstract rules directly into the real-world courtroom. This is where cases are quite literally saved or lost. Understanding the distinction between mandatory and directory provisions. A mandatory provision requires strict compliance. If you mess it up, it invalidates your act. A directory provision, on the other hand, is the preferred course, but non-compliance doesn't automatically void the whole proceeding. So how do you tell them apart? Well, a seasoned practitioner will always ask, who actually benefits from this rule, and did breaking it cause real prejudice to the other side? For example, time limits imposed on the court are generally directory, but time limits imposed on the parties, those are treated way more strictly. Knowing this distinction is exactly how you save a case from derailing over a minor technicality.
And honestly, this aligns perfectly with how the highest courts view the matter. Check out this guiding philosophy from the Supreme Court. A technical procedural defect that causes no prejudice will ordinarily not nullify proceedings, but a defect that deprives a party of a fair hearing strikes at the root of the court's authority. The absolute crucial takeaway here is that procedural rules exist to advance the pursuit of justice, not to frustrate it. The court will often overlook a harmless, innocent error, but it will absolutely never forgive a breach of natural justice.
But, what happens when you face a totally bizarre situation and the code is completely silent? It happens. That brings us to Section 151, the inherent powers of the court. This is the CPC's ultimate residual safety valve. Courts use Section 151 to prevent the abuse of the judicial process and to fill in the gaps where the code just doesn't explicitly provide a rule. Think about recalling an ex parte order that someone obtained through blatant fraud. Section 151 ensures that justice ultimately prevails even when the rigid text of the law simply runs out of road.
So, as we wrap up this explainer, I want to leave you with a final provocative thought. Is the Code of Civil Procedure just a rigid set of hurdles, or is it actually the vital machinery required to achieve ultimate justice? Listen, if you treat it like an obstacle course, you are always going to be fighting the system. But if you truly understand its architecture, the delicate balance of rights, remedies, and finality, the CPC becomes your absolute most powerful tool for delivering substantial justice for your clients. Thank you so much for joining me for this deep dive. Keep learning, keep questioning, and I will see you in the next explainer.